AIMA refused my application because a document was missing. The problem? Nobody had ever asked me for it. That sentence appeared in an expat forum, and it captures the moment that makes people feel completely powerless. You search your email, you search your downloads. There is the document. There is the portal receipt. There is even a timestamp showing that you sent it. But the file still seems to say, missing. Before you treat that warning as the end, stop. A proposed refusal and a final refusal are not necessarily the same thing.
Welcome to Portugal Rights Rebel, episode 86. I'm Elena Vargas. Today, we tackle one of the most common nightmares expats face in Portugal and show you exactly how to fight back legally and effectively. My position is simple. If the authority is still considering a refusal, your job is not to send your entire life story. Your job is to make the decisive mistake, missing fact, or misunderstood document impossible to overlook.
You may see the Portuguese phrase audiência dos interessados, often translated as the hearing of interested parties. In broad terms, it refers to an opportunity to comment before an administrative decision is finalized. But do not turn that broad explanation into a guarantee. Immigration procedures can be affected by Lei 23/2007, regulations, current agency instructions, and special rules for the specific application. The Código do Procedimento Administrativo provides an important legal framework, but it does not answer every question by itself. Before you write a word, identify the document in front of you. A message saying, in substance, you may submit observations before a decision is made is a different animal from one saying, your application has been refused. A request for an additional document is different again, and an automated processing update may be neither. Copy the exact Portuguese wording into your notes. Do not rely only on an automatic translation or a quick summary from a friend. Save the complete notice, every attachment, the original language version, and the proof of delivery. If it came through a portal, download the page and preserve the submission history. If it arrived by post, keep the envelope and delivery record. Write down the date you received it and the date you accessed it. If the notice gives you 10 days, record that immediately, but do not casually assume how the period is counted. Ask qualified counsel to confirm the trigger, the calculation, and the valid filing channel. What should you extract from the notice? 4 things first. The proposed reason for refusal, the facts or legal rule being relied on, the response deadline, and the permitted method of submission. Then look for instructions about accessing the administrative record. If the document says a final decision has already been issued, stop calling your response a hearing submission. You may now be dealing with an appeal or judicial remedy, and the deadline may be different. Here is the strategy I want you to remember. Answer the issue, not the anxiety. Build a 5-column table. In the first column, copy each concern exactly as the authority states it. In the second, write your factual answer. In the third, identify the document that supports it. In the fourth, note the legal or procedural point your lawyer should verify. In the fifth, state the outcome you want. Accept the document, correct the record, request clarification, allow more time if permitted, or withdraw the proposed refusal. 5 columns. That is enough to turn panic into a plan. And notice what is not in that table, a 20-page biography. If the notice says proof of accommodation is missing, do not answer with, I already sent it. Answer with the date, the filing channel, the reference number if one exists, and what the document proves. Attach the receipt, the accommodation document, and a clearly named copy. If the real concern is the document's validity period, answer that concern instead. The largest file is not automatically the strongest file. This is where document preparation becomes legal strategy. Passports, civil certificates, criminal record documents, bank evidence, employment records, insurance, tax material, and proof of family relationships may each have different rules. Translation, certification, apostille, authentication, and validity periods can matter. A document accepted in one application does not automatically satisfy another. Check the notice, the current official instructions, and the rules for your exact route, whether that is a D7, a D8, family residence, an investment-related application, or another category.
Make the bundle usable. Put a one-page index at the front. Number every attachment. Use names such as 03 passport, 04 certified translation, and 05 proof of submission, instead of leaving files with names generated by your phone camera. Put documents in chronological order when timing matters. Number the pages in a larger submission. Then refer to the attachment number beside each important factual statement. You are not decorating a file. You are giving the decision maker a short route from the concern to the proof.
What if the document is genuinely unavailable? Be specific. Say what you requested, when you requested it, why it is delayed, and what substitute evidence you can provide. Keep the request confirmation or official explanation. If the procedure allows it, ask whether the authority will accept an alternative or permit additional time. Do not write, AIMA lost my file, unless you can prove that. Write instead, the portal receipt confirms delivery, but the document does not appear among the materials identified in the notice. Facts are harder to dismiss than accusations.
One applicant sends the same enormous bundle 3 times. Another writes a powerful account of sleepless nights, family stress, and months of uncertainty, but never answers the question about the document's date. I understand why that happens. Bureaucracy is exhausting, but an emotional narrative cannot substitute for the missing legal and factual link. Use the human consequences where they are relevant, then connect them to evidence and the legal framework. Family circumstances can matter significantly. If a proposed decision could affect a spouse, children, dependent relatives, or an established family life, identify the relationship and the practical consequence. Provide the documents that support it. Depending on the procedure, proportionality, equal treatment, and respect for family life may be relevant, but naming those principles does not automatically defeat a refusal. The question is how they connect to the exact facts and whether the applicable immigration rules allow them to influence the decision. That is a point for individualized legal review.
Here are 2 anonymized case lessons. In one file, the proposed refusal rested on a missing document theory. The response was only a few pages, a short chronology, a portal receipt, the document itself, an appropriate translation, and a clear request to correct the record before deciding. The submission did not shout. It made the error easy to see. The other file arrived as a digital avalanche. Hundreds of pages, repeated uploads, emotional messages, and no direct answer to the decisive question about the document's date and authentication. The file looked busy, but the issue remained unresolved. That is the contrast. Concise does not mean careless. Detailed does not mean disorganized. A lawyer reviewing your response should verify the procedural stage, the category rules, the evidence requirements, the deadline, and whether the authority actually addresses the material evidence you submitted.
If a final refusal arrives anyway, preserve it exactly as received and record the delivery date. Do not assume the response you prepared for the hearing automatically becomes an appeal. Ask a qualified Portuguese lawyer to identify the available route and calculate the deadline. Depending on the procedure, that could involve an administrative mechanism, judicial review, or another legal action. The right remedy depends on the decision and the applicable rules, not on the label you choose in a podcast.
You may also hear about an ombudsman complaint or contacting a European Union institution. Those channels can be useful for certain administrative or broader rights concerns, but they are not automatic appeals. Do not assume that contacting an ombudsman or an EU body pauses, extends, or replaces the deadline for challenging your individual decision. Protect the primary remedy first. Escalation can be considered separately, with advice about its purpose and limits.
Today, create one folder and place 5 items inside it: the notice and delivery proof, your application receipt or file reference, a dated chronology, the 5-column evidence matrix, and a draft attachment index. Add a calendar entry for the earliest possible deadline, plus a reminder to obtain professional confirmation. If you have already received a notice, do this before organizing anything else. The system is slow. Your preparation shouldn't be. The central lesson is not that every applicant has an identical hearing right. The lesson is that you must recognize the procedural moment you are in. If a refusal is still being proposed, read the notice closely. Identify the decisive concern. Answer it with usable evidence. Preserve proof of delivery, and protect the deadline. If the refusal is final, switch immediately to advice about the correct remedy. Do not confuse participation before a decision with an appeal after one.
This episode is educational information, not legal advice. Portuguese immigration procedures, filing channels, translation requirements, and deadlines can change, and special rules may apply. Have the actual notice reviewed promptly by a qualified Portuguese immigration lawyer. Save this episode. Build your deadline and evidence map today, and share it with someone facing a possible refusal. Knowledge is your best defense. Document everything, act lawfully, and protect your future. Always consult a qualified Portuguese lawyer for your specific case. Your rights don't disappear at the border.